Hey guys, quick note. This is a clip show made up of a couple different Roman law talks and or classes that I've given over the past pandemic year. So this may not flow as well as it might, but you'll get it faster. So do give this a listen before we meet for class on Wednesday. Gosh, what time is it? What month is it even? At any rate, sit back and enjoy this overview of the Roman legal system for the purposes of trying magic relevant cases. Talk more on Wednesday. Peace. Now, before we get into the law itself, we need to talk about the first step towards going to trial in ancient Rome, and that is getting caught. Something that's very different about ancient Rome as compared to, say, modern America, is that there aren't police departments as such. Instead, Romans relied on a community policing model. So theoretically, anyone in the community could enforce the law on anyone else. And this goes right on into filing cases. More about that later. There weren't, conversely, people in the city of Rome who were authorized to use force to catch people in crimes to a degree farther than other people in the community. In other words, everyone had about the same right to use similar amounts of force. Now, in practice, this meant that people with more money, more power, more connections were able to enforce the law better than people who didn't have that kind of resource. This is very much a social network thing. The social network is what you succeed and fail by in an ancient community. This often involved things that would look a lot like modern gangs or mafia connections. Like you would have bosses who would have people working for them and sometimes several levels of people, and then they would use that force to defend their group's rights and also to quash any protests coming from their opposition. If you're wondering, well, didn't this turn into violence in the streets? Well, yes, often. If you're interested, Google Publius Clodius Pulcher. Treat yourself. He's super entertaining, and I'm kind of fond of him. Now, in the provinces, it gets a little bit more complicated because provinces were governed by a Roman governor, often, in fact, almost always, with a military detachment, at least one, probably more than one legion. And this meant that in the provinces, if you violate Roman law against a Roman citizen, more about that later, then the military can come after you, grab you, and bring you to their justice. And there's going to be more of this in provinces that are more contended. So Roman Britain, for instance, because it was a garrison for several legions, but also it was an island with locals who were really not fans of having their country taken over by Rome. Indeed, I can't really blame them for that. This meant that there were lots of military around, and there were a lot of armed conflicts for them to intervene in and try to quash. Another case that you're probably more familiar with than you might think is Roman Judea. If you've read any of the New Testament, or if you're familiar with Maccabees, no, let's leave Maccabees out of this for a minute. If you're familiar with the New Testament, you're familiar with Roman military policing in a province which has its own internal legal system and legal process. Often, Roman provinces would have two different systems of laws, their local system and then the Roman system. over time, local systems tended to give way to the larger Roman legal system, not necessarily because Roman law is the best. We're missing a trick if we go there, but rather because of the way Roman citizenship worked. If you were a high-status Roman citizen, your case would be heard in front of the provincial governor himself. And any Roman citizen had, amongst other rights, the right to appeal a decision in the city of Rome. So if you know that a Roman citizen is going to contest your case and take it all the way to the city of Rome, you probably want to start with Roman law in the first place in an attempt to diffuse things before they get to that point. And that's what we see on the ground. And if you're interested in learning more about provincial administration and governance, your best literary sources are going to be from Britain, Judea, and Roman Egypt, which is nice because this gives us the three corners of the empire to compare and contrast, which excites me because I'm a nerd. I love that stuff. I mentioned that who you are makes a difference to what your trial looks like and what your access to the legal system looks like. So let's talk about this some more. By the way, these are portraits of actual ancient Romans. They're taken from the Fayum mummies. This is in Roman Egypt. So you're looking at some real Romans. Hi, real Romans. I'm going to start with the good news because this is going to go to a bit of a dark place. You're familiar with Romans. You know how this is going to end. But let's start with the surprise good news. For women, the Roman legal system does have a decent amount of access. Now, I'm not talking equality. It's not a paradise. There's some real problematic elements to how gender is handled in Roman law. But there are some things that might surprise you here too. For instance, women are as equally able to file suit as men. They have that citizenship right. They can also defend themselves in court. Eventually, there's a mechanism that allows some women to have access to the court system without a legal guardian. This is the law of three children, or the right of somebody with three kids. And this was a measure introduced by the Emperor Augustus to encourage people to have more Roman babies. So if you had three children, you automatically got the right to access the court system without an official male guardian signing off on it. Some women went so far as to argue their case in court themselves. And although this isn't super common, it wasn't particularly weird either. Our direct evidence of court systems, so those papyri and tablets I was talking about earlier, show that a lot of both plaintiffs and defendants in Roman court systems were women. And indeed, some of them spoke and argued their case as their own lawyer. Hortensius springs to mind here. So that's the good news. There's, of course, some bad news on the gender front here. As I mentioned, if you didn't have the right of three children, which you either got by having the three children, and it was if like your children died, you still got to keep it, so it wasn't three live children. Just if you had given birth 3 times, that counts. However, you could also be granted the right of having 3 children, even if you hadn't actually had 3 children. This is something that Pliny the Younger gets, for instance. Even though he didn't have 3 kids, there's some perks for men who are fathers here too. But the real payoff is going to be for women. And one of the things that you might try to petition for if you're a prominent Roman woman in your community, say you have a good amount of money, you're building things for your community, you're well respected, you can petition and win the right to effective legal personhood. They also get to own their own property, which, yay! So that's some happy news too. Now, on to the place where there are no winners. That is, of course, slavery. As you guys are aware, ancient Rome was a slave-owning society. Roman law was built from the ground up to keep enslavement as part of the system. In other words, Roman law took a lot of pains to maintain the power of enslavers over the people they had enslaved. And for this, I'm going to use enslaver rather than owner, because that's what you're doing when you force someone to do labor for you. That is enslaving someone. Also, I'm going to avoid using the term slave. Instead, I call them enslaved people, as do a lot of other scholars who work on the history of slavery, because they are people, right? You don't stop being a person when you're enslaved. You don't get this whole new name for a new category of humans, slaves. No, you're a person who happens to be enslaved at this time and this place. So that's what I'm going to go for. When in doubt, emphasize people's humanity. It's one of the few things we can do to bring some justice back to the many, many people who were trafficked under Roman rule and Roman law. If you are enslaved, then you can't bring a case to court. Your enslaver can, but your enslaver can't bring a case to court for you to get compensated. Rather, your enslaver can file a suit to get money to compensate them for damage to you or your death. More about that in a bit. Similarly, there was a belief, this was commonly accepted wisdom of ancient Rome, that enslaved people will not tell the truth unless they have been tortured. And here's where it gets very depressing. This actively makes me very sad. So the only way an enslaved person was allowed to give testimony in court was if they had been tortured. Which I can't add anything to other than to pause, because it just makes me really angry, actually. And I think that's okay, right? We can love learning about the Romans without co-signing on every single thing the Romans did. And this is an important one to resist the urge to be drawn in by. Now, there are some differences between rules for enslaved people in ancient Rome and rules for enslaved people in America, particularly before the Civil War. There isn't an effort to keep enslaved people illiterate. To the contrary, an enslaved person's market value rose with their level of education. So the people who were trafficking them would often make sure they were educated. This means that doctors, engineers, things we think of as high status professions today were professions held by enslaved people in ancient Rome. Let's see, what else do I want to say about enslavement? Oh yeah, enslaved people also have few to no civil rights. For instance, they didn't have the right to make decisions about their own bodies. There are some areas in which some rights were given, but very limited. For instance, the Emperor Claudius put it into law that if you abandoned your enslaved person while they were sick and they got better, you can't take them back. They're automatically freed. So if you abandon someone while they're sick, then if they live, they get to be free, which is such a low bar, yes? But I do give the Emperor Claudius kudos for that one. It's one of the first bits of civil rights for enslaved people in history. not giving him a gold star for that. I'm just saying, if this strikes you as wrong, it struck some ancient Romans as wrong too. So Romans perpetrated massive injustices, but it's okay to criticize them for it because other Romans resisted. They pushed back, they protested, they refused to be part of the enslavement system. And I'm here for those Romans. Like, that's fantastic of them. There should be more folks like that. All right, so what else do I need to say about enslaved people in this context? That'll be all that's useful, because we need to move on to freed people. Romans would often release people from enslavement in their wills, and this was something called testamentary manumission. This, however, does not come without strings attached. Even if you're freed during your enslaver's lifetime, they then cease being your enslaver and they become your patron, your patronus. More about patronage to come. And there were obligations written into Roman law between a patron and their dependents. The Roman word for that is client. If you were found to be an ungrateful freed person, technically, under Roman law, you could be re-enslaved. Now, this had the effect of incentivizing manumission, but we should be careful about being too happy about this, because it encouraged manumission so that an enslaver could free a person. They would no longer have to be responsible for as many costs for that person, but they could still, and often did, have the legal right to demand services for free. So even though you'd been freed, you're not totally free when you're a freedman. You still have an obligation to the person who last enslaved you. You also carry that person's name as your new Roman name. So erasure is written into this process, and there's still a good deal of obligation and coercion. Now, if you are freeborn, your parents were freed during their lifetime, is the rule of thumb here. Then you didn't have the same kind of obligations, even if you had a patron. First, you could sometimes choose your patron if you were freeborn free agent, and if you weren't happy with your patron, you could take a risk and jump to a new patron. Good luck with that. I hope it works out. But not all freeborn people are created equal in this society, because your prominence makes a difference in what your punishments look like in the system. Also, your citizenship status is a really big factor in determining how your case will go, both for official reasons and for social reasons, unofficial reasons. As I mentioned earlier, Roman citizens had a right to appeal their decision and have a case reheard in Rome. Not any case, mind you, but if, say, there had been some kind of technical irregularity with the process in your first trial, then you could file for the appeal. Or if your first trial had been heard in a provincial court by locals rather than, say, by the governor, and this is something that Paul does in the New Testament, in the book of Acts. In fact, the plot of the book of Acts is largely taken up with Paul's contact with the Roman criminal justice system, which is one of the reasons why I'm very fond of that particular chapter. So if you're interested, go check that out. It's fun. This meant that if you don't have citizenship, you're at a bit of a disadvantage. First, if you're in the city of Rome and you don't have citizenship, you yourself cannot move to have your case heard in a Roman court. Now, if a Roman accuses you of a crime, then you go to a different praetor than if you're two Romans going to court with each other. The peregrine praetor, or the praetor peregrinus, goodness, was the city of Rome person that you go to for this. And you needed a separate court for this because conflicting citizenship and loyalties made for more complicated caseloads. See, anything else? No, that's about what you need to know going into this. Alrighty. So we talked about you. Now it's time to meet your advocate. Your advocate is the person who argues your case in court. And this doesn't quite match up with Roman lawyer, or with modern lawyers rather. In the American system, lawyers fulfill both the role of jurist and of advocate. This is a split thing in ancient Rome. Your default advocate is going to be your patron. So if you are a freed person, you would go to the person who formerly enslaved you. If you were an immigrant, you would try to make connections with a powerful Roman and hope that they'd show up for you when you needed them. And sometimes this works out. Cicero, for instance, had some non-citizen friends that he did go to court for. You could also try to hire an advocate on the open market. This you would do if your normal patron wasn't willing to argue your case, or if you wanted to hire somebody who had more expertise, like, say, Cicero, then you could indeed hire them. Now, depending on how prominent this trial was, advocates would often do this for the exposure. Frequently, they were very wealthy anyway, so they weren't suffering for cash, and they could make a lot more use out of political and social capital when it came to election season than they would make out of a monetary transaction. But some lawyers, or rather advocates, especially the ones starting out, would hang around the courts waiting for people who needed an advocate and couldn't find one. This, by the way, is a picture I found of some modern reenactors. The guy in the middle shouldn't be your advocate. That's clearly a druid. Druids weren't considered trustworthy lawyers, so you probably shouldn't hire a druid. But we've got a distinguished dude in a toga praetexta. That's a good person to call. The word, by the way, for advocate is advocatus, that you're familiar with, but sometimes you just call them your patronus, your patron. So if you were to yell, say, expecto patronum in the middle of downtown Rome, you wouldn't get a spectral deer. What you would get is a Roman in a toga ready to defend you in the courts. That sounds kind of useful to me, actually. All right, you've got an advocate, you know your social status. Now it's time to file your case. This is the first stage of a trial under the formulary system. And what you do is you arrange a meeting between the two parties, plaintiff and defendant, and then you go to see the praetor. So praetors weren't bench judges like American judges are. Like, they're not going to be hearing your case for the most part. Instead, they decide whether or not your case has merit and can go forward. Under the formulary system, you do this by filling out a form, hence formula, and it has to say, when did the crime occur? What was the crime? What law are you going to use? Who are the witnesses? It's the basic facts of the case. So you create this document, you take it to the courts, you wait in line to get your hearing in front of the praetor, and the praetor will decide whether the case goes forward, and then will also adjudicate who gets to be the judge. This brings us to private and public cases. These are the two major categories of cases and laws in Rome. Private cases are cases between two individuals, often a citizen and another citizen, but citizens can take non-citizens to Roman court, and if that sounds like a bad situation to be in as a non-citizen, well, yeah, you're right, it is. Non-citizens don't do so well in this environment. But you can't take a private case to court if you're not involved in the crime. So if, for instance, your neighbor's chariot gets stolen and is wrecked, you can't go to court to recover damages for the broken chariot. It has to be your neighbor who does that. You can be his advocate, but the neighbor's got to make the complaint. Public cases, however, were cases involving crimes that were felt to affect the community as a whole. These are things like murder, eventually, after 81 BCE, murder, parent killing, theft, treason, maiestas. These are the kind of things that were felt to strike at the fabric of the community, and therefore everybody in the community is technically a victim of this crime. Now, Romans did not have states prosecutors. There's no attorney general. So there aren't people whose entire job it is to take murder cases to trial. Instead, this is what we call a self-help system. So if you, a Roman citizen, find out that there's been a murder and you think you know who did it, then you've got everything you need to file a case. And then this case will be heard before a panel of multiple judges. So there's not one presiding judge in a murder court. There's like a panel. Eventually you have regular panels that just do nothing but listen to murder cases. Now, you may wonder, if there's no state's attorney or prosecutor's department, well, like, did a lot of crimes go unaddressed? Well, yes and no. What ends up happening is that people who want to make a name for themselves find cases to involve themselves in. Cicero is another great example of this, right? Cicero would make other people's trials his business, take the case to court, and then publish the speech. And he's not doing this necessarily for the money. A lot of advocates didn't charge for this. You're doing it for the exposure. And in high-profile trials, that's great exposure. This is how you form your identity as a politician, and this is also how you get your name out there so people want to vote for you. Because court systems aren't just places where the people involved in the trial are hanging out. This is also public entertainment in the ancient city. Any ancient city. Rome was the Hollywood of ancient trials, but even like tiny towns in the countryside would have regular court days, and if you had the free time and you're super bored, you'd go watch the court cases because other people's drama is super entertaining. We have entire genres of TV shows and movies that exist on this principle. Court's fun. People fight, they argue with each other, they're like rules. It's a bit of a competitive sport. This points at a larger feature of Roman law. This is what we call a self-help system. It's a legal system that's meant to function without a lot of professionals and without a lot of barriers to access for citizens. Theoretically, if you're a Roman citizen, you can be your own lawyer, you can file your own case, and you can be super successful at it. In practice, though, you're going to be a more successful lawyer if you've had public speaking training, if you have insider knowledge about the court systems. So what ends up happening is that professional advocates win cases more regularly, and people with more money have better outcomes in the court systems. which is still a problem that we're dealing with as a society, yeah? Trials look very different for wealthy people and impoverished people. So we're still working on this one, and maybe someday you will figure out a better fix. The next thing I want to bring up briefly is evidence rules. There aren't a lot. We find everything from coroner's reports, you'd get a doctor to look at the body, witness statements, eyewitnesses, and also witnesses of legal documents. You could file documents themselves as evidence, bloody clothing, and there isn't a process for throwing out evidence or including evidence. That's new. We added that because problems arose in systems without evidence rules. Rome, it's pretty rough and tumble. You can bring up anything, including irrelevant personal information about the people in the case. If you want to see this in action, check out the Procilio. Oh my goodness, the Procilio. Poor Claudia. There is, however, one very important and very depressing evidence rule that you need to keep in mind here. Namely, enslaved people were not allowed to give evidence unless they had given it under torture. Romans believed that an enslaved person would only tell the truth if they were physically forced to do so. And that's one of the many things that really horrifies me when I think about it at any length of time. Finally, at the end of the case, for private cases, you'd get either a premium or a columnium. A premium is a monetary award. Private cases are all about damages counted in currency or valuable goods. Valuable goods includes human beings. There's a thing called noxal surrender, where if someone that you enslave commits a crime, instead of showing up and being that person's advocate in court, instead you can give that enslaved person to the victim of the crime, and then that becomes the new owner. That's called noxal surrender. And dear goodness, that's also horrifying. Now, for civil cases, if you take the case before a judge, and private cases were often heard by a single judge that you'd pick off a list, you'd both agree on who you wanted to hear the case, and then the hearing would happen in that person's atrium, usually, or some other agreed on place. You didn't use courtroom facilities for that. Courtroom facilities are for public places. If you accuse someone of causing damage and it's found that they aren't liable, you can be given a fine for filing a suit without merit or basis. So you might end up having to pay damages. So keep that in mind. This did nothing, by the way, to stem the tide of people using the court system in Rome. The court systems were massively backed up. Just because there aren't states prosecutors, Romans seem to have gotten along quite well. Alrighty. On to the Lex Aquilia. This is the point at which there aren't any more images, so if you like listening to this like a podcast, knock yourself out. Here we go. The Lex Quillia constitutes the bulk of the legal material in the primary sources that I had you read this week. The Roman law of governing doctors in medicine is taken from a larger compilation made by the Emperor Justinian, and it's a copy and paste mashup of several hundred years of Roman legal scholarship. You don't need to know this to do this week's exercises. I just feel responsibly I have to put that out there. Okay, so the Lex Equilia governs most of what's happening in civil law impacting physicians. Civil law, distinct from criminal law, refers to disputes between private citizens in which the state does not feel an interest. These are things that we still do in civil court. So this is like compensation for wrongful death or damaged property, and the same things that Romans use this for, we use this for. Libel is another thing Romans have a category for, we do too. This is going to be a little different in criminal law. I'm not going to spend as much time with criminal law either because I made you read my book chapter about it. So Lex Equilia, I'll spend some more quality time with here. Roman laws are named after the person who proposed the legislation. The Lex Aquilia was proposed by this tribune named Aquilius. It gets an A on the end of it because the Roman word for law, lex, is feminine, so Lex Aquilia means the Aquilian law. And this was the law used to regulate property damage. Property is a key term here. We'll get into that in a minute. The test by which you determine responsibility under the Lex Equilia is a reasonable person's caution. This, for Romans, they'd phrase as the kind of responsibility that a responsible head of household, a responsible pater familias, this Roman male head of household, the person in charge of all of the family and enslaved people and children and so on within the house, and also the person who was your primary go-to patron if you were outside of the family but affiliated. So this guy is the smallest unit of the Roman state, is the male head of household, the pater familias. So the good father, the good male head of household, was this legal construct of this responsible, caring administrator of family property in trust for future generations. And the idea here was that if somebody else's property ends up in your hands, you have a duty of care to that property that is equal to the care you would exercise if you yourself owned it. The example that comes down to us in Roman legal discourses, if your neighbor's pregnant horse wandered into your field and you needed it to not be in your field because it was eating your grass or whatnot, then you had a right to treat it as if it were your pregnant horse. So you couldn't beat it because it might miscarry. You can't yell at it or traumatize it. You're supposed to pen it up and keep it safe and feed it and take care of it until you can get it back to its owner. So that's the duty of care that we're imagining here. Now, there are limits. Self-defense is an exception. So if somebody's pregnant horse attacks you with a machete, you don't have the responsibility to just let it chop you into tiny pieces. How it would, I don't know. But just go with me here. You can defend yourself. That's going to be important for your clients. There are also assumed levels of risk. So if, say, no, I'm going to go here now because after this, the horse metaphor is just not going to work. Remember, Romans own humans, and human beings are property under Roman law. So we're not just talking about horses, we're also talking about human property, enslaved people and trafficked people. So if, say, you're attacked by someone who's somebody else's slave and you kill them in self-defense, that's the kind of situation that's also being imagined here. Now, Roman law also recognizes that some activities carry an inherent risk. So, for instance, if you find yourself in a boxing match with somebody else's slave, and that enslaved boxer ends up dead, their owner can't turn around and take you to court because by entering a boxing ring, you are agreeing to be pummeled to a bloody pulp. Therefore, you have assumed a level of risk. this is going to be really important when we talk about healthcare, because Romans are not really in agreement on what constitutes an assumed level of risk in healthcare. I mean, quite frankly, this is something that we're still adjudicating in our own society, yeah? As new medical technology happens, as standards of care change, the standards by which we judge negligence or incompetence also shift. And negligence and incompetence looks different for different kinds of medical practitioners and different sorts of circumstances. There are a lot of judgment calls that have to take place when we're talking about a medical defendant. This is magnified by a ginormous amount when we're talking about Roman medicine, where there's such broad disagreement on such basic concepts as what is a human body anyway, and are there humors in it or not? And did that humor cause that disease, and how do we treat it? This makes it really difficult to talk about incompetence and levels of risk, but Roman law tries. And yay, it gets an A for effort. You can fault the Romans for all kinds of things, but they certainly are triers. Okay. Ownership and property, as I mentioned, is a really big deal for determining negligence and responsibility here, but it's also an important test for your clients. Before you can use the Lex Equilia, the first question you should be asking yourself, maybe the second question. The first question is like, okay, does this meet the bar for negligence? The next thing, though, equally important, is has property been damaged? And here's where it gets super messed up. Keeping in mind, Roman law had to preserve slavery as an institution, or at least it felt that it had to preserve slavery as an institution. For that, they needed a definition of what is an enslaved person? What is it that makes an enslaved person different than a free person? And the definition they come down to is that an enslaved person's body can be purchased. It has a price tag attached to it. Therefore, a free person's body cannot be priced because a free person's body has no market value. It cannot be bought and sold. And this was, for Romans, a human rights issue. Roman law was assiduous in defending the idea that if you were of free status, you could not legally be trafficked. And if you were trafficked despite being of free status, then the person who trafficked you is now in breach of Roman law. This isn't to say it didn't happen. It happened all the time. The reasons why there are laws about this is that people were constantly getting kidnapped and trafficked in another part of the Mediterranean, so much so that it's a huge trope in ancient romance novels. They love it when pirates kidnap the heroine and then she's enslaved and she's really free, and it's Roman novels are fantastic, guys. They're really amazing. For our protagonists, though, what this means is that to put a price tag on the body means that you are effectively demoting them to an enslaved status. So that the only kinds of dead or damaged patients that you can sue for are patients who are enslaved, which pretty much eliminates like all of modern malpractice suits. Yes, all civil malpractice suits put, well, maybe not all, I hate all, it's categorical. Probably there's like 2 cases that don't do this, but most malpractice cases are about putting a monetary value on the damage to the patient's body. And then monetary values are given also to pain and suffering, compensatory damages, lost wages, ongoing medical expenses, and we're kind of going there in a minute, so hold your horses. There are some things that a free person can sue for, but bodily harm is off the table. you can't argue for lost value if your body has no monetary value. But this also means that if you, a physician, are treating an enslaved patient, your liability suddenly just got a lot more complicated, which is also pretty interesting. I suspect that the impact on the patients involved was that it was harder to find a physician to treat an enslaved sick person. So I give Galen all kinds of grief, but he willingly and out of the goodness of his heart does seem to have treated enslaved people and done so really well. It's the ancient world, folks. The bar is low for human decency, but good job, Galen. Gold star. I do respect that. All right. Almost immediately, Romans tried to figure out where the limits of this are, where the edges are. They start with underage dependents. So because the male head of household is not just the authority figure of the family, but also he officially owns the family's property. In fact, if you're under the age of 25, you yourself cannot own property under Roman law. Here we're talking about men. The rules are a little different for women, but not different in a way that makes it any better when you're under 25. If you're a Roman woman, you have to have 3 kids. Or 4 if you were enslaved at any point. Yippee. So then, male head of households began to wonder, well, what if my son who is under the age of 25 is injured? Since I legally own his work and I manage his money, if he is injured, I have effectively lost income from a dependent, and this is a little bit like losing one of my enslaved people. And keep in mind, Roman slave law is very similar to Roman parental law. In fact, creepily similar. You're, for instance, allowed to kill your children if they step out of line. So that's what I mean by similar. It's considered tacky, but you're allowed. It seems that eventually there was some movement on this, that you could treat a dependent son, that is a son under the age of 25, or a son with certain disabilities that prevented him from reaching full adult status, maybe, you could get compensation for damage to that body, but likely not to the extent you could for an enslaved person. Similarly, you could sue for lost wages. So not bodily damages, but loss of income. You had to prove actual damages, what we call actual damages in law. That is the precise value of income lost by calculating what their income was before the injury, what it would have been within a year. The text of the Lex Equilia tells you how to calculate that. It's different for complete death versus just damage. So look there for details. The next thing, once you have established A, the Lex Equilia applies, B, there is negligence, the next thing you have to do is talk about actually, no, I'm going to back this sentence up. The sentence is a loss clause. Okay, intent is not important in the Lex Equilia. So you don't have to have intended to kill your patient to be liable. Just not having taken the appropriate amount of care you would have if you were that patient's pater familias. So if you were drunk or ignorant or just sloppy, or you chose to operate on a ball field. I wish I were making that example up, but no, there's an actual case that happened with a guy who was a barber who was shaving a client on the edge of a ball field, and one of the ball players' balls hit him in the arm, and then his arm slipped, and then he accidentally slit the throat of the person whose beard he was shaving, who happened to be enslaved, therefore Lex Aquilia. this is what I love about ancient law, guys. It's basically like wall-to-wall Florida man stories. It's lovely. So you've got to argue that somebody screwed up their duty of care. Somebody didn't anticipate a foreseeable consequence. Somebody wasn't doing things to an acceptable standard. And again, this is hard in medicine because acceptable standard is impossible to define using the state of science in the first centuries CE. But some of your cases ask you to try, so do your best. You all do, however, have to establish causation. So it's not enough to have, like, the doctor operated and then the enslaved person dies. You need to establish that the death occurred as a direct result of that physician's intervention. And this means for surgery, it's pretty easy. You just have to show that the physician cut there and then it got inflamed. I mean, we'd say infected. They don't know about infections because that needs germ theory, but like the patient got worse and died. You could argue, of course, that's part of the assumed risk. So you'd have to be like, they operated and clearly cut the wrong thing, or it's the wrong hand, or you have to be able to prove that they did it wrong. But causation is pretty easy in surgery. In pharmacy, it gets difficult because you aren't holding the patient down usually and forcing the drug into the patient's body. Sometimes you are. For instance, drugs administered via an enema, that is rectally or vaginally as a douche. They're also sometimes put in through the nose, the ear, that kind of thing where you are directly administering it, you're good. But if, say, it's in a bottle and the patient takes it themselves, that's felt to be enough of a break in the chain that you need to prove that they took it as a result of the doctor telling them to, and more about the nitty-gritty details of that in a minute. In fact, yeah, here, let's do the nitty-gritty details. This brings us to the last thing that you're going to see in your primary source reading this week, the Fragments of Roman Law I had you read. Legal theorists, not necessarily courtroom lawyers, but legal theorists were very interested in a concept they called an in factum action. And that needs a little bit of explanation. The in factum action was one of the brilliant innovations of Roman law. This was a process by which a judicial official, not necessarily the trial judge, but the judge who allowed the case to proceed. Part of why you needed this step in the process was so that official could sign off on the in factum process. So if your case doesn't fit the letter of the law, if somebody didn't directly break your slave, but if a physician incompetently prescribed a medication that the slave then took and then subsequently died, that's the territory we're in here. It's not the letter of the Lex Equilia as written, and you can read the letter of the Lex Equilia at the beginning of that section. I gave you the whole thing so you can kind of look at the letter and see. You can say it is effectively the same kind of scenario as the Lex Aquilia. That's what in factum means. In factum is Latin for the indeed or the in practice. This is a scenario that is close enough to the wording of the law that you can use the law to resolve the case. So this lets Roman law become much more flexible than the initial wording of the statute, and this also means that Roman law didn't have to reissue the same laws over and over again as technology changed. Rather, what they do is they build up this library of cases where a judge was like, okay, that's close enough. Yeah, you can use the Lex Aquilia to go forward, or no, that's not quite like the Lex Aquilia. That doesn't count. Go back, try again. That's why there are all of these cases preserved in the section on the Lex Aquilia. Like, some of it is just the wording of the Lex Aquilia, and then there's this list of example cases that are used to show whether, okay, is this a direct or is this an action in factum? Is this a close enough kind of action? Now, when it comes to trial, this in factum thing doesn't seem to have made a huge amount of difference. It might have impacted the maximum damages a little bit, but it seems to be more something that people on the administrative end of the legal system worried about than lawyers and clients. Now, a few words about how these trials went down. Lex Equilia trials, because they were part of private law and not public law, would take place when both parties agreed on a single judge, and there seems to have been a list of Romans in good standing that you could pick off the list. And then these didn't have to meet in a courtroom. They would often meet effectively in the judge's living room. So you'd both show up on a given day, you'd argue your own cases. So this is one where an advocate would be nice, but you don't necessarily need one to access decent justice here. This is a pretty low-key process. Roman law was designed to be primarily a self-help system and meant to minimize the number of judicial officials involved and also maximize the access of individual citizens to the system. This meant that court costs were pretty low, but also that trials were very informal and very non-standardized, because there's nobody standing there in that judge's living room saying, this is nuts. You could appeal, but you could only appeal saying that the action shouldn't have gone forward because technically it doesn't quite fit. So it's not, your backseas options are pretty limited in a civil action. Now, one other thing about civil actions, and this is in your reading, but I want to make sure I bring this out so it's clear. If you are being accused in a Lex Equilia case, you have a big decision to make. Because if you deny the charges and you're found liable, you're going to have to pay double. This was meant to discourage unnecessarily contesting charges and to make the court backlog not quite so bad. Rome's courts had a ludicrous backlog. Pretrial hearings themselves just took up most of the business in the forum. If you tried to go to the forum, you'd be tripping over people trying to get their legal paperwork done. Like, this was a high volume system, partially because it was a high access, decentralized self-help system. And if you've met Romans, they argue a lot, much like us. What else did I want to say about this? Yeah. So if you contest, you might have to pay more. So you may find yourselves in a situation where you don't fight the charges and just eat the costs because you know things don't look great for you. Let's talk about not killing your parents. We are now moving from private law to public law. Now, murder legislation doesn't seem to have been a thing until 81 BCE, but parent killing always was. This is because, in part, it was assumed that murder, when you kill someone who isn't in your family, then you're gonna work out a fine with that family. They looked at it as a self-help situation where you'd carry on vendettas or you'd make people pay until you'd resolve the matter. In fact, it got super toxic and violent, so that's why eventually they had to make murder a crime. But if you kill someone older than you in your family, that's inside the family unit. This is a crime where there isn't another family to point out the crime and take it to court. This is a situation where the state has to intervene to make sure that heads of households aren't being killed willy-nilly. And heads of households should worry, because younger members of the family may want them to die so they can get a hold of their money. There might be toxic situations with children from multiple marriages. There's all kinds of stuff that goes on inside of families that is toxic and abusive and not great. And unfortunately, this is something we share with the Romans. Now, what's interesting here is the punishment. You may have heard of this one, but if you haven't, here it is in the Latin again. I'm going to paraphrase. So the punishment, if you're convicted of killing your parent, or your aunt, or your uncle, or any family member who's up from you in the pecking order. Your mother-in-law, however, is specifically excluded from this. Oh, Romans. Okay, so you're convicted. You are given the punishment of the sack. This doesn't mean you get fired from your job. This means that there's a giant bag that you're put into along with 4 live animals. They're listed here: a canis, a dog; a gallo gallicaneo, a gallus gallicaneus is a rooster; vipera, a viper; and a simia, a monkey. I always thought this was very unfair from an animal rights perspective. I mean, also human rights, but these animals didn't do anything. All right, so these animals are sewn up alive with you in the bag. Then the entire bag full of critters and you is thrown into the ocean, where you drown as you're being poisoned and pecked to death by increasingly desperate animals who are in the bag with you, which is just so sad. Now, this may strike you as kind of an impractical punishment. It's a punishment that relies, first off, on being close enough to the sea that you can dump people into it. And yeah, this is the Mediterranean, but not everybody lives on the beach. At some point, somebody wrote a letter to the Emperor Hadrian asking, hey, do we have to do the whole bag ocean thing if we're landlocked? And Hadrian says, okay, if you're not next to the sea, then it's close enough to just throw people to the wild animals in the arena. Like, they're animals, you die horribly, good enough. Well, that's delightful. Oh, no, it's not all I have to say about that. There's more about this law. So this is the strictest law for adultering. And this, I've given you the Latin here. What this means, the Lex Quillia de Adultery, the Julia, laws were named after the person who introduced them. We still do this, right? We have bills like the McCain-Feingold bill for campaign finance reform. So the Lex Julia, the Julia part is from Gaius Julius Caesar Jr. So Augustus was adopted by Julius Caesar, and that's why his family name is still Julia. But this is super ironic, right? Because Julius Caesar was one of the most famous adulterers of ancient history. His heir decided to really overcorrect. He was almost like pathologically fixated on stopping adultery, so much so that he calls this law the Julian Law, right? Augustus's law about adulterers. The full name of the law is the Julian Law about the adulterers who must be stopped, which is just a great law. It's my favorite law name from the ancient world, or ever. And as I mentioned, this is all about man-on-man crime first, and then you punish the woman later. I mentioned the thing about pandering and pimping, so if you don't prosecute, then you're in trouble. Double jeopardy does apply. So if you sue the man for adultery first and he's acquitted, you cannot then go after the woman for adultery. However, if the man is found guilty, it's probably not going to go well for the woman. However, you're legally required to sue the man first. Now, so far, this sounds sensible. Here is where, for ancient Romans, this began to really go off the rails. Because it wasn't just the people involved in the adultery who were liable. If your friend commits adultery and you know about it and don't inform on them, you could be sued. If you let somebody use your house for adultery, you can be sued. If someone has adultery on your couch and you find out about it and don't report them, you can be sued. If you maybe sort of know that somebody might be committing adultery but don't do anything about it, you can be sued. Likewise, anybody is allowed to accuse anybody of adultery. What this means is that the court load for adultery cases goes through the roof, so much that they have to build a purpose court where they have a panel of judges that are constantly impaneled hearing adultery cases 24/7. So the drama potential for this is massive. It's also a great thing for entertainment. Ancient Roman trials for criminal law, which this was, were public. So people would go and popcorn to upper class people's adultery drama. Now, to limit this a bit, there was a 5-year statute of limitations. So if you cheat on your spouse and nobody finds out about it for 5 years, you are in the clear. Now, also, if you have adultery with somebody's wife, the wife dies, you can still sue the man for adultery, but only for 5 years. Now, this law was eroded almost as soon as it was passed. There was protest poetry. People ended up exiled for the protests, including, and here's where this gets sad again. I'm so sorry, this is a depressing lecture. Augustus's daughter, who was named Julia, because that's how Roman names work. Remember, they're not very creative about this. So Julius Caesar, massive horn dog. Augustus, legislative overcompensator. Augustus's daughter, Julia, was an intellectual leader and one of the opposition leaders to many of her father's policies, including this one. She had been married off to a series of politically convenient husbands, one of whom, Agrippa, was much older than her, and then her final spouse, Tiberius, was by all accounts abusive, and not even by all accounts. Her life ends in a way that makes it very clear that he was an abusive a-hole. Julia was one of the first people accused of adultery, prosecuted publicly, and all of the people involved were subsequently exiled, including Julia. She was sent to an island called Panatria. It's a very, very small island in the Aegean, so small that it can't grow its own food, so all of her food had to be shipped in. She was kept in isolation. And then when her father died, the new emperor was her ex-husband Tiberius. The first thing Tiberius did almost when he became emperor was he stopped the shipments of food to Julia's island, at which point she starved to death in exile, which is why I am fairly certain that it's historically valid to call Tiberius abusive, because that was abusive. So this has a really sad ending, but there's some good news here too. This is not how all Romans felt about sex and sexuality. A lot of Romans thought this was too much. A lot of Romans deviated from the standards, some publicly, some privately, with more or less degrees of hypocrisy. Just like any society, people are people. You're going to find a wide range of acceptance levels and safeness. But then there's also this icky dynamic about sleeping with people's spouses to do revenge things, and that's gross. Next. So, what do we do now? You've been convicted. As I mentioned, for private crimes, it's going to stop with your money. But for public crimes, you risk what Romans called your caput. Now, that's your literal head. Yeah. But it's also your personhood, metaphorically. This means that for some people, you do get literally killed. For other people, you lose citizenship, you lose some civil rights, you lose your property, you lose your freedom, you might be sent away from your home to live in exile. On the lighter end of this, you can be temporarily exiled. That's called relegation, where you're sent to an island for 10 years, then you get to come back. Your family holds on to your stuff. It's all good. For upper class people, it's written into Roman law that you should have a lighter sentence. So exile, property loss, you might still die, but it's rarer. For people of lower social status, so you're a citizen, but you're not a prominent citizen, you don't have a lot of property, you're not influential, it is more likely that you're going to get killed. However, not guaranteed. You might be sent to hard labor in the mines or on construction projects. That might sound like it's a pretty okay deal. It's not, though. Mining wasn't very safe in antiquity. It's still dangerous today. There's no OSHA regulation. And because this is labor sourced from convicts, there's not a lot of concern about whether or not your miners die. In fact, a lot of them do. And this is planned for in the models. And there are enough people being convicted that you can replenish this labor source. If you're mining silver, there's a large amount of lead, and they didn't know that lead poisoning was a thing. They didn't quite get how dangerous small doses of lead are, but they did understand that too much lead will kill you. In copper mines, arsenic, there are other heavy metals too. It's just not great. You're probably going to be dead within a few years at best. And you don't get off the hook with construction projects. Again, there's no OSHA. People regularly died building walls and aqueducts and roads when stones fell on them, when machinery went awry, when your crane broke. There weren't safety nets. There just isn't a great life expectancy to that kind of a job. Then there's death, but not all death is the same flavor of death. There's a merciful, swift death, or you could be thrown publicly to wild animals in the arena, there to be killed in front of a cheering crowd. And this was part of the point. This was meant to be a deterrent. It's essentially a terror tactic that the state used to point out and prove that the state was doing something about crime. And they didn't even make an attempt to be fair to all citizens. It's literally in Roman law everywhere that if you are of lower status, then it's the beasts for you, or you'd be put into a low stakes bout at the beginning of a game where you would be killed by a gladiator. Or if you did not have citizenship, you could die a horrible, painful death of asphyxia while you were being crucified. You could also be starved to death. This is a thing that happened to some people. Not just low status people either. Some members of the imperial family ended up dying starved to death, locked in a room. It's just very sad. But also a big part of Roman culture. This wasn't private. This was something done with witnesses. Witnesses were part of the point. And this was done in order to dehumanize criminals, to keep people from sympathizing with them, and to get people to identify with the Roman state and the Roman community. And it was successful enough. We see it in art depicting what are meant to be like exciting, juicy drama scenes. But before we judge the Romans too much, think about the way violence happens in our media. How many acts of simulated murder we watch as a part of our own entertainment. And particularly in criminal justice themed shows, who do these shows ask us to sympathize with? How well do these shows treat issues of inequality in our criminal justice system? The answer to that is pretty telling. Now, I'm not saying that we're as bad as Romans. I don't think there's like a scale for this. It's just something I think about when I'm looking at Roman law. It happened 2,000 years ago, but humans are humans, and it's telling just what has changed and what hasn't. There's a lot of work that you guys have to do when you grow up and go off to practice law. So if you're interested in this topic and you want to know more,